We've heard over the last day about a number of risks and harms from social media. We've heard about bullying. We've heard about people who've seen horrifying images of suicide and self harm, which has pushed young people to harm themselves. We've heard about child sexual exploitation, depression, loneliness. And so I'm really glad to be here today with Sir Peter Wanless of the um, largest children's charity in the UK, and with Rob Bonta, the Attorney General of California, because these folks are pioneering safety regulations for children online. The UK has been a leader in passing really strong laws, and Sir Peter's going to tell us about it. And California has been leading with children's protections for a really long time, and with privacy protections, is kind of the pioneer in the United States. So, Sir Peter, I wanted to start with you. Can you tell us a little bit about the NSPCC and what you do?
Yes, sure. So we are a child protection charity. We were founded in 1884 with the charitable purpose of preventing cruelty to children. And I think the founders would be horrified if they thought 140 years on we hadn't solved this problem, but maybe they didn't foresee the internet and the online world, among many other things. So our purpose is to remain absolutely true to children and young people and to try and listen and understand them and do everything we can to give as many of them as possible the best start in life. So that's our purpose. Within our charity, we run Childline, which is a 24/7 service here for any child who feels that they have nowhere else to turn. It's well known by pretty much all kids across the UK, and it gives us a unique insight at scale into what young people are thinking and feeling about their lives at any given time. So we are counselling 200,000 plus sessions a year, and we use what we hear and understand from young people to design and develop our services, to inform our campaigns, and to seek to influence a world in which we prevent cruelty to children, we protect kids from abuse, and we change attitudes, behaviours and laws to look out for children.
And Attorney General Bonta, can you talk a little bit about California's pioneering role in tech regulation? Because we always say, as California goes, so goes the country, whether it's environmental issues. But here with privacy, you are the seat of Silicon Valley, so there's also some pushback. And I was hoping you could tell us a little bit about the history of that.
Sure. Well, thank you. First, thank you for the opportunity to be here. Thank you to Common Sense and Mr. Steyer for your vision, your leadership, your friendship, and the whole team bringing us together for this important conversation. Always excited and inspired when we have so many folks from around the country, around the world, committed to protecting the health and safety of our children. And in California, we are proud to be the state that has led to the phrase, as California goes, so goes the nation. We want to be first, best, on the cutting edge, the front foot, innovating and doing and delivering results. And that certainly includes protecting the health and safety of our children. And I believe it's a false choice to say that you're either pro-business or pro-children. You can certainly be both, and we should aspire to be. You can have successful businesses that treat children well and look out for their safety and their health. And we believe that some of our tech companies, many of them, can and should do better. And we have provided the pathway for how that can happen. And we are in a state of emergency, a state of crisis. We can't turn away from where we are when it comes to the many challenges our children are facing online and the impacts on their mental health, on their physical health, anxiety, depression, suicidal ideation, body image challenges, learning loss, isolation. And it needs to change, and there are ways to change it. So as Attorney General of the greatest state in the nation, I try to use all the tools in the toolbox, including enforcement of existing laws. So we have lawsuits and investigations into tech companies who we believe knew about the harms to young children that they were causing and lied about it to the public. And we are also working with our legislative partners. As a former legislator, I believe in the power and potency of legislation and policy to do more, to do better. When you have something that is addictive, whether it be gambling or alcohol or drugs, it should be regulated. And so should addictive online experiences. So yesterday we introduced two very important bills to move the ball forward when it comes to protecting children. Shout out to Senator Nancy Skinner and Assemblymember Buffy Wicks for their leadership and their partnership. Maybe we can talk about those later if you're interested.
But since I definitely want to ask you about those two new bills, but since you mentioned litigation as another avenue to try to increase protections for children, could you talk a little bit about the lawsuit against Meta that 33 states has filed, because California is one of the leaders, and there was a deep investigation? And can you tell us about some of the things you found and what you want to do to push Meta to change?
Yes. After a 2-year investigation, bipartisan, multi-state attorneys general from across the country, red and blue states, and you rarely see, unfortunately today, bipartisan efforts like this where there is agreement on the problem and the solution. So proud that we've come together across political differences and geographical spaces to align, and we last fall sued Meta for creating harm online to children, that anxiety, depression, et cetera, that I mentioned, and knowing about it, having studies internally that talk about it, but in outward-facing public statements, denying the harm, or promulgating and putting forth studies that dilute and minimize the harm. They have said publicly that they don't try to maximize engagement and duration of engagement for children, but we have internal evidence showing that that is exactly what they do, that they don't try to have addictive experiences for children, they say publicly, but internally we know that they're talking about how it is addictive. They also talk publicly about how they deplatform and kick off children who are under 13, so that, which, if true, would comply with the Children's Online Privacy Protection Act. But we also know that they've said internally that they believe 30% of 10 to 12-year-olds are on their platform, and they are collecting their data in violation of COPPA. So we learned all that in our investigation, and we wanted to be, certain and clear and sure about our evidence, and we filed a lawsuit that's based here in Northern District of California to hold Meta accountable. And the main remedy that we seek is injunctive relief, behavioral change, different approaches to how children have experiences on their platform. And the case is in the early stages, but we're very excited about the momentum that we've built and the flag in the ground that we've planted.
Because we don't see this scale of investigation very often, right? The scale of this investigation is the scale of the big tobacco investigations of opioids, of Juul. Yeah. All right, yeah. Sir Peter, I wanted to ask you about the Children's Code, because the UK a few years ago passed a landmark law to protect kids online. And before the law even took effect, tech companies started saying they were putting changes in for children as if the law wasn't happening. So YouTube announced it was going to turn off autoplay, which is the videos playing one after another, because it was causing kids to spend hours and hours online. TikTok suddenly announced that all accounts for children aged 13 to 15 would be turned to private by default. And this was like in the weeks before the law took effect. So could you tell us a little bit about the Children's Code and what it requires, and was it hard to get through?
Yeah, so there were a number of us who'd been campaigning hard for much better behavior by the tech companies, and had got to the point where we felt I remember going to a meeting with the minister involved and saying, what is it that makes you think that the 13th or the 14th self-governing code is going to be any different from the last one? We really need regulation. And we were told regulation wouldn't make any difference. The companies knew what they wanted to do. They were well-intentioned. And a rather pragmatic opportunity arose in the context of a piece of data protection legislation that was going through the Parliament to attach a children's code. And a great champion for children, Baroness Beban Kidron, pushed this amendment forward, which placed around 15, from memory, obligations on companies that were aiming services at children to have regard to, whether that is switching off the automatic geolocation or automatically having the highest privacy settings for children, et cetera, et cetera. I mean, simple things, not resolving the problem in a fundamental way, but demonstrating that were clear things that could be done to keep children safer than would otherwise be the case. And you're absolutely right. As it became clear that was going to pass, it was striking how many companies adjusted their behaviors in relation to these 15 elements, and then, of course, made a really big deal of it. And I've sat through a whole number of presentations where they've showed me how brilliant they are at looking after children as a consequence of taking these actions. So there we go. I think it was an early indication that regulation works.
It was really interesting also as a journalist because the companies have the opportunity to file their opinions as the law and the regulations are being drafted. And so all the folks who objected suddenly, weeks before, made all these changes. And so this children's code has had a profound effect worldwide, and I think it inspired California. Do you want to talk about that, Bonta, the age-appropriate design code and how that was related to the British effort?
Yeah, having been in public policy for some time now, having that privilege, I've realized that there often aren't that many brand new ideas. They're just ideas that haven't been used here yet. And if something is working somewhere else and people can benefit here, bring it here. And so we were inspired and grateful for the leadership in the UK on the age-appropriate design. Assemblymember Buffy Wicks, that great leader once again, authored the bill to get it passed and signed into law here in California. And so we learned from the UK's successes. And we also learned that successes today might face challenges down the road. And we're in court now. We have a challenge from Net Choice, and with a dormant commerce clause and First Amendment challenge, and they've actually prevailed at the trial level, but we think the court got it wrong, that there's no First Amendment right to collect children's data and use it for addictive algorithms, and we're appealing.
Assemblymember Wicks couldn't be here because there's legislative things she has to vote on, but she did describe, how she worked on the law with Baroness Kidron, who helped shape the UK law, and also how she worked with a lot of tech companies to try to draft a law that they said that they could comply with. And then they turned around and filed a lawsuit to stop this law that had been unanimously voted in by the California legislature. We're seeing that nationwide, so I'm going to ask you about that in a minute. But after the British Children's Code, Sir Peter, then there was an even kind of more comprehensive law that just passed, the Online Safety Act. And I'm wondering if you could talk about that, because it's taking aim at a bigger slice of issues.
Yeah, sure. So data was one dimension of children's lives online, but what young people were saying to us was, we are fundamentally unsafe when we go online, and this was evidenced by the scale of grooming crimes against children, 34,000 over 6 years. Tragic consequences of algorithms serving up dangerous and damaging materials to children, et cetera, et cetera. So we campaigned for an online safety act that would presume safety by design and require companies to have regard to the safety of children online. And it was a struggle. It took the best part of 5 years, 4 prime ministers, 7 secretaries of state, endless meetings of wriggling and complexity and all the rest of it. But time after time after time, the politicians sided with us and with the overwhelming public opinion that said it is not an option when it comes to the fundamental safety of children. The basics of child protection should be designed into the online space just as they are in the offline space. We don't allow chokeable parts in toys or lead paint or whatever it might be. There shouldn't be features of these online services which we can see are having inevitable consequences for the well-being of children. So that act was eventually passed after, say, 5 years. Not only was it passed, actually, but at the beginning, the NSPCC set out 6 tests for what good legislation would look like, because it's quite easy to pass law, but it's another thing to pass law that actually has a positive impact. And at the beginning, the first draft of the bill, I would say 1.5 of our 6 tests were met. By the time the Act was eventually passed, as a consequence of the scrutiny by fantastic, parliamentarians who made the most of this opportunity, cross-party, 5 out of the 6 tests were met. And we now have a workable basis for building on now. So it's a moment, I think, of genuine triumph and pride for us to be able to say that the fundamentals of child protection are built into the law in the UK for the online bits of children's lives as well as the offline bits. Now, that's just the start. Ofcom, who is the regulator, are now going about demonstrating and consulting on how they are going to enact this law. So for Christmas, they delivered us 1,600 pages of guidance around the first code on illegal harms, and we've got another one around how pornography is going to be handled. And this is painstaking and important work, and there's an obligation and a responsibility, I really feel it, on us as the NSPCC to make sure that these guidance documents are as strong and effective as they possibly can be, because in discussing these, we're up against some companies with extremely deep pockets, extremely large legal and public affairs departments who are looking carefully at how they can water down significant elements of this, whereas we're trying to sort of build up to ensure that the documents are robust. So that's going to be important. It's then going to be important that we get alongside Ofcom to ensure that they assertively implement the powers within the Act. And then the third thing, which is really important to us at the moment, is the voices and perspectives of children and young people. So the one test that we didn't meet was we'd like to have seen written into the regulatory regime a body that would articulate in real time what children and young people are seeing and experiencing online. In many regulatory environments, you have consumer bodies that do exactly that. We didn't manage to get that written in, but there seems to be strong commitment from the top of Ofcom to look after that dimension. And from the NSPCC's point of view, that's what we are going to champion now. This regulation will only work if we are seeing and understanding all the time exactly what it is children and young people are experiencing online, because we will see improvements made by various companies to make things better than they otherwise might have been, for sure. And we've had another little cluster of them announced, haven't we, ahead of the hearing tomorrow. Kind of no surprise with that timing. And all these developments are good and they make things better than they otherwise might be, but the final, judgment of is this working or not is what are young people seeing and experiencing themselves.
So I would theorize that it is perhaps easier to pass such laws in the United Kingdom because you do not have the First Amendment and you do not have this thing that we have, Section 230, which basically absolves online services of responsibility for content created by others. So this notion that the internet could be ruled, like product safety, that cars should have airbags, cars should have seatbelts, social media, that's a bigger challenge for you. So I'm wondering if you could talk about that a little, but also now you have these 2 new bills that you sponsored that were introduced this week, one of them which does get at the design of algorithms and their impact on young people.
Yeah. We often see reliance from the tech industry on Section 230 and on the First Amendment, and those do not give them absolute immunity to do whatever they want when they want, and to do the things that are harming children. They just don't. Section 230 prevents liability for a social media company for the speech and content that others use on their platform, but they are responsible for what they do, for their conduct, for their behavior, for the design of their social media platforms. And that's what we are getting at. Not the speech of others, not their right to free speech, but their conduct and their behavior and their design. And we think that a fair hearing in court will support our approach to compliant regulation that is consistent with Section 230, that is consistent with the First Amendment. And we have two bills that we introduced yesterday that we believe are compliant with those laws. One is Senator Nancy Skinner's Protecting Youth from Social Media Addiction law. And that bill provides default settings that are required by social media platforms that put the control and the experience of children in the hands of parents and in the hands of children. It starts with the default setting of an organic chronological feed from people that are already, the individuals already connected with, and from searches that have already been conducted. It provides for no notifications or alerts from midnight to 6 a.m. Not a very radical approach for a child when they should be sleeping. It also allows parents to set other times when a child might not want to receive alerts and notifications, like when they're doing homework. It also has a default setting of 1 hour of use a day, and then access to the social media platform gets turned off. That can be changed. All of these can be changed. But those are the default settings. And parents and children should have control of the experience that they want. And for the first time, when this bill is passed, it will provide for a customized experience designed by the parents and children who will have agency. We also have the Assembly bill authored by Assemblymember Buffy Wicks, which is the California Children's Data Privacy Act, which fills some gaps and closes some loopholes in current data privacy protection for children, and prevents the collection, use, disclosure, and sale of information of children under 18. Full stop. Right now, data can be collected and used, although not sold, for those under 17, and it can be collected, used, and sold for 17 and above. And so this provides additional protections. The data can be accessible if there is an affirmative opt-in and authorization by the child if they're over 13, and by the parent of the child under 13. And then it has teeth in that we have $5,000 penalties per incident where the AG can move in and hold social media platforms accountable when they violate the law. So these were introduced yesterday. We're super excited about them. We think that they're cutting edge and groundbreaking in terms of the protection that they provide for our young people and the regulation that they legally impose on the industry.
Well, thank you both, and we'll be following further developments. We know that other states are introducing bills that resemble the age-appropriate design code. We know that the UK's laws are having an effect all over the world, so we're eager to see what happens next. Thank you.
Thank you. Thank you.